Namaste students. Today's our topic is merger control exception expanded. Better late than never. D. Minimus exemption extended to merger and amalgamation as well. Assets and turnover of only the portion which is being transferred to be considered for the purpose of the merger control thresholds. Methods of calculation of assets and turnover of such portion are also provided. On March 27, 2017, the Ministry of Corporate Affairs issued a notification under the Competition Act 2002, which provides for the following. Number 1. An increase in the type of transaction that would be exempt from seeking approval from the Competition Commission of India (CCI) under Section 5 and Section 6 of the Competition Act on the basis of certain. D. Minimize therefore a more commercial way of computing the value of assets and turnover for the purpose of Section 5 of the Competition Act in case of acquisition, taking control of or merger of a portion of an enterprise or division or business. An extension of the de minimis exemption for a period of 5 years from the date of publication of the 2017 notification. Unless specifically exempted, the Competition Act requires every combination to be notified to the CCI in the manner set out in the Competition Act. Read along with the CCI Regulation 2011 and seek approval prior to effectuating the same. The CCI in turn is required to make a determination as to whether such a combination is likely to result in causing an appreciable adverse effect on competition for Section 6 of the Competition Act. Makes void any combination which cause or is likely to cause an appreciable adverse effect on competition within India. In terms of Section 5 of the Competition Act, a combination involves the acquisition of control share, voting rights or assets of an enterprise by a person. The acquisition of control of an enterprise where the acquirer already has direct or indirect control of another engaged in identical business, or a merge of amalgamation between or among enterprises that cross the financial threshold set out in Section 5. The financial thresholds for a combination are determined with reference the combined assets value and the turnover the acquired and the target in the event of an acquisition and the combined resultant company in the event of an amalgamation or merger, and the combined assets value and the turnover of the group to which the target resultant company will well be pursuant to the proposed acquisition merger. The CCI has undertaken the combination regulation specified a list of transactions that would not ordinarily require notification before the CCI. The Competition Act also permits the central government to exempt certain enterprise or class of enterprises from the application of the Competition Act in public interest. In furtherance in the provision of the central government had under a notification the 2017 notification had enacted the 2016 notification and the de minimis exemption in terms of scope as well as term. While there is no increase in the thresholds for the assets value and turnover, the 2017 notification intends to cover more situation in relation to small enterprises and transactions. We have analyzed the changes brought about by the 2017 notification. Extension of the de minimis threshold.